Welcome to the 2025 LA Fires, a year in review, and what's ahead in 2026. I'm Belinda McCauley, BHBA's Executive Director and CEO. Just over a year ago, right after the fires, our speakers today presented a public service webinar through BHBA about how to file homeowner insurance claims. More than 10,000 people watched that webinar, which was scheduled for an hour but ended up going more than 2.5 hours, so that the attorneys could answer a huge volume of audience questions. We received extensive feedback about how helpful that program was, so we invited the speakers back a year later to share more of their time and expertise. So I'm honored to be here today to introduce them. Amanda Riddle is a partner at Corey Lusick, DiGitaldi, and Riddle LLP, where she represents clients in complex litigation matters, including business, employment, and mass torts, while also serving as the firm's managing partner. A recognized leader in mass tort disaster litigation, she has held court-appointed leadership roles in major wildfire and explosion cases, helping secure a landmark $13.5 billion settlement in the PG&E bankruptcy and more than $1.5 billion in compensation for more than 6,000 victims. Ms. Riddle also leads the firm's employment law practice and is known for her commitment to public service, including co-founding the San Mateo County Bar Association Legal Clinic Committee to provide legal services to unhoused people. Stacey Monahan Tucker is the founder and principal of Monahan Tucker Law, where she leads the firm's insurance practice, which is focused on complex disability, life, and long-term care matters. After earning her law degree from the University of Chicago Law School, she spent the first decade of her career at Jones Day and Quinn Emanuel in San Francisco, representing insurers in high-stakes litigation involving multi-million-dollar claims. Her background as a management consultant to national insurers and a lead insurance litigators provides her with deep insight into the most complex insurance disputes affecting executives, professionals, and business owners. Stacey also chairs BHBA's insurance law section. John Torbett is a trial lawyer at Kramer Law, whose practice focuses on complex business, real property, and insurance litigation, including bad faith, landlord-tenant, partnership and governance disputes, entertainment, and securities matters. An experienced trial advocate, he's tried multiple jury and bench trials and FINRA arbitrations, securing 7-figure judgments, numerous 6-figure settlements, and a $5.6 million inverse condemnation verdict against the city of LA. Mr. Torbett brings industry-specific insight from representing clients across film and television, real estate, finance, hospitality, and digital commerce, as well as from his early career work in the entertainment industry following his education at Vanderbilt University and SMU Dedman School of Law. And now let's get started.
Hi, I was here a year ago talking with all of you about what your options are in the face of a massive disaster like losing your home in a wildfire, especially when thousands upon thousands of other people are dealing with it as well. We delved last year into the weeds quite a bit on what the current state of the law and regulations were governing these issues. I'm going to do a quick review of those since I realize not all of you were with us a year ago and also are living our lives and not dealing with insurance regulations every day. So just to start with, as a quick reminder, the California Department of Insurance has issued a variety of regulations that largely went into effect in 2024 and the beginning of 2025, just before the wildfires. One of the things we've seen is that insurance companies, partly because these are new and partly because insurance claims adjusters are all over the country, often abruptly assigned to these California wildfires, they don't necessarily have a background in knowing the law in California and the regulations they have to follow. So as a reminder to you, and you can remind your claims adjusters if these remain issues, your insurer, if you lost your home, was required to advance 4 months of additional living expenses immediately upon the loss of your home. Hopefully, that's a non-issue, as this is well in the past, but be aware of that. If you are still struggling with living expenses and they did not do an advance, that is something you can push on. They had to offer an immediate payment of at least 30% of the value of your coverage A. Coverage A is the home replacement, up to $250,000 for your personal property, which is usually listed as coverage C. They don't have to exceed the value of your personal property, but they do have to go up to $250,000 if you have that much coverage. If you are making a claim and you're fighting with the insurance company about how it's set up, you don't have to use their forms. You just have to provide them the information in any format that's easiest for you. You can bulk list items. You don't have to itemize everything. If your insurer is pushing back on this and causing a lot of delay and frustration, you can remind them of that. That is Insurance Code Section 206A23, if that's helpful. Even if your property was unharmed, your insurer was required to pay living expenses while you were restricted from accessing your property. As you know, many people were unable to access their homes, even if they weren't destroyed in the wildfires, because the entire neighborhood was closed off. If that remains an issue for you, you can continue to push back on that. Also, your insurer has to provide you a copy of the policy, the entire policy, not just the declarations page. They have to provide you all documents in your file upon request. They don't seem to know that most of the time. So if you want to know everything that's happening in your claim, you can demand a copy of all claims-related documents under Insurance Code Section 2071. That can let you see the information they're working with and their internal notes about what's happening. They have to respond to questions, letters, calls, and emails within 15 days of receiving them. They are supposed to accept or reject a claim in full within 40 days of receiving proof of the claim. This is something that's hard to tie insurance companies to, because what constitutes receipt of proof of the claim when it's an ongoing claim and an ongoing rebuild process? In reality, nothing is going to be done within 40 days, as I'm sure all of you living through this are well aware. If your claim is denied for any reason, they have to put all the factual and legal bases in writing in the denial letter. And if they accept the claim, they have to pay all the undisputed portions within 30 days. As I noted, the regulations provide a pretty easy way around these timeframes, though, because they can ask for more time if they need to dig into something more. They just have to note that they're taking that extra time in writing. As you've seen, claims adjusters are overwhelmed during disasters. They have hundreds upon hundreds of files assigned to them. Everybody wants immediate assistance, which is understandable. Insurance, because of that, the insureds often didn't have a point of contact that they could rely on. And the California Department of Insurance requires somebody who's been assigned to 3 or more different claims adjusters in a 6-month period. The insurance company now has to provide a written status report summarizing what's happening in the claim and provide one ongoing person to be a stable point of contact. If you've been dealing with that and your insurance company hasn't been following that, that is now required under Insurance Code Sections 2071 and 14047. So you can push back on your insurer if you have no idea what's happening and you're just getting bounced around and not getting any clear answers. Be aware, you can get up to 24 months of additional living expenses automatically, plus an additional 12 months. So a full 36 months if you're encountering delays in your rebuild. A lot of people have been asking me if that extension also applies to purchasing a new home. And no, it does not. This applies to rebuild because there can be so many difficulties in rebuilding. The same difficulties don't exist in identifying and purchasing a new home. So you do not have up to 3 years to find a new home at your convenience while you are living on ALE. Be aware of that. That's been coming up a lot. Also, if you are having difficulty with your insurance company agreeing on what it's going to cost to rebuild, you should invoke the appraisal provision in your policy. Every insurance policy has one. You can demand appraisal. Both sides have to pay for their own appraiser and split the cost of a third neutral appraiser. All 3 of those appraisers look at what it should cost to rebuild your home, and agree on an amount. And then the insurance company is tied to that amount. They have to pay it. This is by far the fastest and cleanest way to get the amount that it will cost to rebuild your home quickly and indisputably determined. Many of the calls I've received have been looking to hire an attorney to represent them in these negotiations. And to be clear, you don't want an attorney to hire you to represent you on an ongoing basis with your insurance company. It does not speed it up. It simply costs you a lot of money. And on top of it, if you hire a lawyer during the negotiation process, that lawyer is quite possibly going to be barred from representing you in any litigation that might be required against the insurance company because they are a witness to everything that happened in the negotiations. So I always recommend finding a reputable public adjuster to represent you in these negotiations if you strongly feel that you need representation. That is literally what they do. It is the reason for their existence. And if you want somebody to represent you, that's the road to go. A lawyer is going to cost a lot more. And in the long run, you anticipate that the lawyer that you hire will be able to help you in any litigation. But in fact, that's not how this works. Also, one more thing about appraisal. If the damage is due to a government declared disaster, the insurer cannot compel you to use appraisal. I believe you can still require it, however. And not every wild victim, as I mentioned, wants to rebuild. You can do anything you want in terms of purchasing a new property, and all of your coverages can be put towards that. That includes extended replacement coverage, separate structure coverage, and building code upgrade coverage. All of it can get bundled into the purchase of a new home. However, you're not going to be able to access those coverages until you show that you are under contract for a new home. So there's a certain amount of a chicken and egg issue that I've had insureds call me about. How do I purchase this if I don't have the funds until after I purchase? It's a good question. Usually you need to go into the mortgage yourself, get all of that set up, and then once you have a contract that you can show the insurance company, you're entitled to the funds. I understand that this is frustrating, but there's no way around it. And as previously noted, the time extensions that apply for rebuilding when you run into delays do not necessarily apply to the purchase of a new home. So keep that in mind. And if hopefully nobody has had their insurance canceled because of the wildfires. The insurance companies are not allowed to do that. They have to offer to renew for at least 24 months after the fire. So you should have coverage at least, you had it through 2025. Hopefully you should have it through 2026 as well. After that, however, it is possible for them to decline to renew. So please be aware of all of that. And what we've been seeing in 2025 and into the beginning of 2026 are an enormous number of smoke and ash claims that people have been struggling with obtaining coverage on, especially with the FAIR Plan. Many people are covered by the FAIR Plan, including in the Palisades and Eaton areas. And the FAIR Plan has taken repeatedly a hard line against providing any sort of coverage for smoke and ash, insisting that it can be simply cleaned up and there's no issues. There was a case that came out in February 2025. It's called, if I'm pronouncing this right, Garibian versus Wawanesa. And in that case, the insured sued their insurance company because they were not damaged at all in the fire, but they had fire debris throughout their property and wanted the insurance company to pay to clean that up. It went to the appellate court in California, and the appellate court held that direct physical loss requires actual damage. and needing to clean up debris does not constitute damage. And so the court found in favor of the insurance company on that. And the FAIR Plan has been pushing on that, claiming that if it can be cleaned up, that they don't need to cover it. However, a number of sources have disagreed on that, including the California Department of Insurance, who is currently pursuing FAIR Plan directly about this refusal to pay for smoke and ash. Because, as those of you living with it know, smoke and ash isn't a simple matter of taking a washcloth and cleaning out your house. It completely can destroy the interior and livability of your home. And that is very different than having to pick up burnt branches in the back of your yard. And so the California Department of Insurance has been focusing on this. And there is also a plaintiff side law firm called Curly Schaefer, who is bringing class actions against the FAIR Plan for all of its various failures, which include the position they take on smoke and ash. My understanding, and I am not involved in this litigation in any way, but just to be clear, my understanding is they are looking at the FAIR Plan's attempts to limit coverage, to fail to meet state requirements, and to refuse laboratory testing and the typical approaches required in remediating smoke and ash damage. I don't know where that stands right now, but I do know that it's been filed, and I would encourage somebody who is dealing with this themselves with FAIR Plan to reach out to Curly Schaefer and find out what they're doing and how you can be involved. I would also encourage anybody who is finding themselves repeatedly stonewalled by their insurance company to the point where their coverage is not being paid or they've received an actual denial, especially with an actual denial, to reach out to counsel and find out what your options are. This is not the same situation as asking someone to represent you in ongoing negotiations. Insurance companies delay. I would love to tell you that that in and of itself is a basis for litigation, but in most cases, it's not going to resolve it. It will take another 2 to 5 years for that lawsuit to get resolved. There may be faster ways for you to get past the amount of delay. And
Stacy,
go ahead.
While you're on those notes, we're getting a lot of questions in the Q&A about loss of use coverage. So if the insurance companies are delaying in paying out, does that result in an extension of the loss of use? If a loss of use is either 24 months or 36 months or a lump sum, and that lump sum has already been paid out, or those 24, 36 months are exhausted before the rebuild was completed, will the insurance company extend that ALE coverage?
They do not have to. There are situations depending on the language of your policy and the exact situation in which you're in, where the insurance company can choose to, but they are not required to extend beyond the 36 months. They are also not required to extend beyond whatever amount is. If there's a cap in the policy, which many policies have caps on the amount of loss of use that's going to be paid in total, they do not have to pay anything beyond that, even if it's taking a ridiculous amount of time for the rebuild. And even if those delays can be laid at the foot of the insurance company, that could potentially be the basis for a lawsuit. And that basis could be a reason that the insurance company could choose to cover this rather than find themselves dealing with an entirely separate lawsuit on this issue. But there is nothing in the policy or in the insurance regulations that requires them to do it. And that is another issue that I hear a lot is we need more ALE. How can I maximize this ALE? It is limited to what is in the policy and the extension that the regulations provide. If you have a cap on it, that cap is a hard cap. They are not required to pay more, even if your house is nowhere close to being built at the time that you run out. I recognize that is not what people want to hear, but it is the law and it is very difficult to get around. So be aware of that. And John, you look like you might have had some experience on that front with your own clients.
Well, we have, and to be honest, a lot of my experience is from the Woolsey fire, and obviously the time frame on getting these rebuilds done it can especially now given the just the volume of permits and everything else. And we've seen. I drove around the Palisades about 6 weeks ago. I saw 9 houses being framed in the main part, kind of where the alphabet streets around the village, just in that area, and thousands of lots just sitting there fallow. But that's unfortunately going to be an issue. And if there's no viable third party for litigation, I mean, typically that's what you do is you sue the responsible party to try to make up the delta between your insurance coverage and what your actual losses are. And unfortunately in the Palisades, and I'll get to that when it's my turn, just the brief discussion of the litigation going on there. That there, whatever that'll be, we'll see how that's resolved fairly shortly. But unfortunately, the insurance, they're obligated to pay out what the contract amount is on the policy. And if you've got losses that exceed that, that's really brutal, but that's just the way it is if there's no viable third party for litigation.
And I'm going to wrap this up because I realize we have a lot to cover. But the other area that I've been receiving a lot of inquiries about is underinsurance. Most people, now that they are dealing with this, realize that they are underinsured and they are very frustrated. They want to blame the insurance company for this, which I completely understand. The courts have been clear. There are very limited situations in which an insurance company can be held responsible for your underinsurance. Most insurance companies on an annual basis provide the summary of your coverage and their estimate of what it would cost to rebuild and say, if you have any questions, contact us. If you received an estimate of what it would cost to rebuild your house broken down into various categories and you did not respond, even if you didn't notice it, if it was buried in a 40-page dump of documents that they give you each year, unfortunately, the courts hold that that's sufficient. The situations in which you can push back on underinsurance are when you contacted and can demonstrate that you contacted your insurer and you asked, do I have enough insurance? I'm worried about this. And they come back to you and they say, yes, you have enough to rebuild. Don't worry about it. If your agent or the insurance company had that exchange with you, especially if it's in writing, that is a situation in which you could potentially have the basis to push back on your underinsurance. Short of that, it is extremely difficult to make the argument that you were underinsured and it is the fault of the insurance company. The law is clear that we choose our own insurance amount. And while we all know in reality it doesn't work that way, that they provide you a number and you accept it, and that's pretty much it, the law was put into place on this a long time ago when you had the option of complete guaranteed coverage. And at that point, the court said, well, if you have the option of guaranteed coverage and you're choosing not to accept that, then you've chosen your coverage and that's on you. Since then, guaranteed coverage has disappeared. There's nothing we can do about that. Courts have decided to continue to rely on the argument that you choose your own coverage. If you contacted your insurer or your agent and asked for more coverage and you were denied, or you asked for more coverage and they told you you had enough, those are the situations in which you may have an argument. Short of that, I've received dozens of inquiries about this. Short of that, there's really not much you can do. And with that, I'm going to turn it over to the people who have been dealing with the third party lawsuits in this, trying to find out who's responsible for the fires and what they can be expected to receive from them.
John,
Amanda, do you want me to?
yeah, do you want to talk, do you have any specific insurance bad faith issues you want to add to Stacy before we move on to third party liability? Because I know that's also your area.
I think Stacy covered pretty much everything. If there are questions that people have, I am dealing with specific cases, which obviously may or may not have any application to anybody out there now. But obviously, there are issues dealing with mortgage payments, and there's been a stay on whatever the term is. There's a moratorium, yeah, on those payments, which is about to end. But I've got a case where a guy had lender placed insurance on a mortgage on a mortgage, and they claimed that they canceled it right before the fire, and we're in the process of dealing with that. I had a guy call me who didn't understand that there was the need to get Fair Plan when he purchased what was ultimately a supplemental policy for fire insurance on his house, but he had lost his previous policy a couple of years ago. And it wasn't clear, he didn't understand at least, that he was supposed to obtain the Fair Plan as the base insurance policy. And he had been then paying for a supplemental policy through his broker. And that should never have been consummated, that transaction, without the base Fair Plan. So he called up his insurance carrier and they said, you don't have coverage for his $5 million house. That's an issue with his broker and the communications there. So at any rate, and then the smoke and ash case is obviously that's ridiculous. What Stacy said is true, and I know this from the Woolsey fire as well. You can have smoke damage to your house, and you have to tear out the wallboard and clean everything out behind for the hygiene, just to clean everything, because there's toxic material in your house, and it's a very tough issue. And we're taking cases in those cases as well, but. The bottom line is that the coverage issues are not easy. Stacy's correct. They're hard fought by the insurance. This is a well documented area of the law. God knows the insurance companies have great lobbyists and statutory protections, in addition to a bunch of case law out there about these, like the Garabian case and others. So you do need to talk to a lawyer, and I agree with you. I think it's counterproductive to get a lawyer when you're still dealing with the claim, if it hasn't been finally denied or granted, because that can end up taking longer, having the lawyer be involved. You need to get the lawyer once there's been a final determination on your claim, and then we can see if there's a basis for a lawsuit. Just one other thing too, the status of litigation in the Palisades fire, people may have heard there was the indictment by the U.S. attorney against the Uber driver who they said it was arson. I don't know if it was negligence or intentional, but either way, he set off the fireworks apparently on New Year's Eve. And I have another guy that wanted me to take a case. He had pictures from Palisades Highlands that he took on New Year's Eve, where the fire was and the smoke. And he literally stood in the exact same position on the morning of January 7th, and you could see the smoke. I mean, the same palm frond and framed exactly the same. That's where it started. And that's the allegation that's in the indictment, which is clearly, obviously, this doesn't mean anything's been adjudicated. They're allegations, but the allegations in the indictment, I think, do, as best I can tell, based on the evidence that's out in the public domain, they allege correctly what happened in Palisades, which is there was the fire on New Year's Eve. They came and put it out. I believe that was the LA City Fire Department, but it was still smoldering. And the hotspot theory is a real theory. I mean, they were talking about that a year ago, even in the press. And there's been video I've seen of the actual the trailhead up at Skull Rock, just right by the Palisades Highlands. It was still pretty evidently smoldering in the days, after, like you could see it. After the fire. And then the allegation is that the wind, the dry wind, and the conditions were so bad on the 7th that it caused the fire to reignite in that same spot. And then that's ultimately what led to the January 7th Palisades fire. So the point is that that's probably a pretty good explanation of what happened. Obviously, the Uber driver is not a viable third party for $25 billion of damage, whatever it may be. The right now there were a bunch of lawsuits filed. I don't believe they've been consolidated yet. But there is a demur that was filed by the city of Los Angeles, and a demur is a challenge to the complaint. It says essentially it doesn't matter what the facts are, just legally there's no claim. So it's a challenge to the pleading itself for whatever, to not get too granular in the legal aspects of it. But the point is that's scheduled for hearing on February 5th in LA County Superior Court in front of Judge Jessner. And it's, there were a bunch of arguments made in those complaints. They tried inverse with, saying that there was no water in the reservoir and the fire hydrants. That's not necessarily an inverse claim, and that's one of the arguments made in the demur. The other problem is that there are some very extensive immunities provided to the city, state, and any kind of public entity under the government code. And there's really no duty even to fight a fire, to be honest. So the point is, and I did a lot of research earlier this year on that to see if there was going to be some basis for liability against the city. I'm certainly not the judge. I'm not going to tell you how the judge is going to rule, but I think that's an extraordinarily difficult uphill battle for these people to get around those immunities. And there definitely was some creative pleading by the plaintiffs. They said that there was an inverse or a taking based on the fact that there was no water in the water infrastructure. I don't know, that we'll see if the judge buys that or not. And then there was another attempt. They found some video of some power lines that were operated by the Department of Water and Power that combusted. And I think that's correct, but the arguments made in the demur that they didn't allege properly, it still may be a question of fact for a jury. But establishing causation that some power lines down at PCH, how did that cause houses up in Marquez to burn? That's going to be a tough thing to prove. So the point is that's an uphill battle, but that's going on. And then the first big event in the litigation for Palisades is going to be on February 5th, and we'll see how Judge Jessner rules. And then there's maybe some other theories. One quick thing too, we're past the 1 year deadline for the Government Claims Act for injury to real property. It's 6 months for other kinds of injuries, but people had until January 6th or 7th, depending on if you think the statute applies to the government claims. I think it does. We're past that deadline now. So if people did get a government claim form in against the state, there may be, I think there's maybe a theory that might be plausible on a dangerous condition, maintenance of a dangerous condition case. But even then, you've got the government immunity. So the point is that's an uphill battle in Palisades. Eaton, Amanda could talk about, that's a whole nother kettle of fish. But it's not over. It's certainly not over because it really hasn't even started in terms of the actual litigation. But we'll find out on February 5th how that's going to work. How that was, the first step. And then with insurance, like I said, Stacy covered it all, but there are different wrinkles in so many different cases. You definitely still have time, and Stacy, correct me if I'm wrong, but I mean, the statute of limitations typically runs from the date of a final determination on your claim, in terms of some bad faith. Yeah.
That is correct. For bad faith, you have 2 years from the final denial.
Right.
And for contract, it's quite a bit longer, although there may be something in the policy that limits. Usually there's a statutory limit.
Usually there's like they set a statute, but then the Prudential case says that they may or may not be enforceable. So the bottom line is, here's the best thing I can say. Time's of the essence for anybody. You've got to just make sure, just consult with an attorney. Don't necessarily have them involved until the time is right in the process of your claim. But definitely, given that, there may be something about the date of loss in terms of that being the time that it sets off or whatever, that starts the clock clicking or ticking. you just need to talk to a lawyer as soon as you can, so you at least have an idea of where you stand in the claims process, and when and if you're going to have to hire a lawyer to file a litigation after there's some adverse conclusion made by the insurance company. But anyway, that's pretty much what I have.
Yeah, I think that, the Palisades litigation is in an unfortunate place. When we look at these fires, the first thing we look at is origin and cause. Who caused the fire? Who could be held responsible for the fire? And as John said, in Palisades, unfortunately, that's someone who's not going to be able to be, sustaining $25 billion of damages and judgments. And then the other component of that case is the spread, the argument that because LA County, the fire department, the California State Parks division, didn't properly maintain water, maintain the environment, that there was a spread. But like John said, the government has a lot of immunities in California. And so it's just unfortunately going to be a very difficult battle to fight. Going to the Eaton Fire litigation, the Eaton Fire, of course, is the one that was in Altadena and Pasadena. We have, a much different situation. That case is just kind of logistically, that case is a mass tort. It is not a class action. So a mass tort is a case where you've got a whole bunch of individual cases and they're related together in front of the same judge. So all of the Eaton Fire cases are in front of Judge Laura Siegel in LA Downtown Complex. When I say individual cases, we generally look at it as a case, by household, because household members tend to have intertwined cases. So those cases are related together. They still remain individual, but they're related together so that all of the common issues can be addressed at once. The common issue generally being who or what caused the fire, and how do we hold that entity accountable. But the cases otherwise stay individual so that they can resolve separately from each other. And this allows each family's unique story and unique damages to be addressed, apart from each other, which a class action doesn't do that. So that's how the Eaton Fire litigation is structured. So in Eaton, who are we suing and why? The main defendants in the Eaton Fire case are Southern California Edison and its parent company, Edison International. The origin of the Eaton Fire is Eaton Canyon. The evidence is pretty darn clear. And for those of you who've seen this ARCO video, this famous ARCO gas station surveillance video floating around, what we know is that there was the origin of the Eaton Fire was Tower 208, which is a small SCE tower up in Eaton Canyon. What we understand happened is that there was a fault somewhere on their transmission system. That fault resulted in a surge of electricity through their transmission system, over-energizing their lines well beyond what they're normally energized at. And that Tower 208, which had actually been de-energized since 1971, but sat in disrepair because Edison had not been maintaining it. It re-energized, absorbed some of that electricity because of the failure in the tower. It sparked and dropped sparks down to the heavily overgrown, mismanaged by Edison vegetation below. And that's what we know sparked the Eaton Fire. So that is the main focus of the Eaton litigation. In the last, I think 10 months now, it's been a year, but the litigation probably kind of got going within a month, 2 months after that. We've done inspections of the equipment, both in the canyon. That tower has been removed. It's been taken to pieces in labs all over the place. Some of it was flown to Kentucky for some special X-ray machine they had there. So inspections of all the equipment have been done. Information has been requested. Documents have been requested from Edison. We are in the middle of depositions talking about, how do they do inspections? How do they do maintenance? How do they manage their transmission system and their towers? What's their wildfire and safety mitigation programs? All of these things lead to failures in their systems that result in these, frankly, at this point, well-known potential events. We also, as I said, well known, we've got this history with Edison in the last several years. They caused the 2017 Thomas Fire, the 2018 Woolsey Fire that John was heavily involved in, the 2020 Bobcat Fire. So in addition to the specific cause here, we've got a history of this corporation placing profits over safety and failing to properly maintain their equipment, running their equipment to failure, and failing to properly fund wildfire and mitigation programs. So that is the focus. Edison has now countersued the County of LA, the LA Fire Department, the City of Pasadena, the City of Sierra Madre, a number of water districts and irrigation companies, as well as Southern California Gas, arguing that because of, for instance, LA County's failure to manage certain vegetation, or SoCal Gas's failure to turn off gas in a certain time, the LA County Fire Department's failure to warn for evacuation, that the fire spread and was more destructive. SCE is probably going to run into a lot of the same immunities that John was talking about. LA County has immunities, the fire department has immunities, the cities will have immunities. And frankly, it's from our perspective, a delay tactic on the part of Edison to try and push, liability or attention and responsibility onto another entity versus taking that accountability on themselves as they should. The first trial date in that case is January 25th, 2027. That's going to be what we call a bellwether trial, which is a trial where in Eaton, there's going to be about 30,000 plaintiffs. So obviously all 30,000 can't go to trial at the same time. So what we do in these mass tort cases is we select representative households who lost their home, households whose home were damaged, households who had smoke and ash, households maybe where there's a personal injury, someone was home, someone was not, representative of the larger kind of docket of cases. Take those to trial, see what a jury would do, and work on use that as a baseline and instruction on what other case values will be. So the first bellwether trial is January 25th, 2027. So that's only a year away, but in our world, a year is not very long when you've got so much work to do. Quickly on the Edison compensation program. So that the evidence is so strong against Edison that they've launched their own compensation program. I don't have time to fully get into it today, but I will tell you that program was drafted by Edison, for the benefit of Edison, without properly consulting anybody who represents the Eaton Fire survivors. It is a program they administer themselves. So the people who burned down your house are deciding how much they should pay you. So, look at it in that context. And they're making take it or leave it offers based on formulas. So, in these cases, it's so important. And many of you know this who were impacted directly by these fires. It's so important to have your voice heard and to have your family's, story told, and make sure that you're compensated, not just some lump sum money, you're compensated. And so the Edison program will not give you that. It may work for certain people who've got relatively simple cases, but for any kind of complex case that needs individualized analysis, individualized attention, the Edison program's not going to do that. In addition, the CEO of Edison, Pedro Pizarro, has publicly said that the purpose of that program is to minimize the amount of money that Edison has to pay out in order to minimize the amount of money they have to take from the California Wildfire Fund. So he's publicly said, look, this is a discount settlement program. So take that for what you will. Deadlines to file on Eaton. So if you are suing Edison and Edison International in Southern California Edison, your deadline to file a case for personal injury, which includes bodily injury, emotional distress, is 2 years from the fire. So that will be January 7th, 2027. Your statute of limitations, your deadline to sue Edison and Edison International for property damage is 3 years from the fire. So that's January 27th, 2028. I do not recommend you wait that long because the train is moving very quickly in that case. But you do have those time limits if you choose to take them. So that is all I have on Eaton. Let's talk about what's happening in 2026. So what's coming is it is a very busy year in wildfire related legislation. So we've got a number of bills that have been proposed. We've got a number of reports that are coming out. From everyone I've talked to, this large focus is really on, how do we mitigate fire? How do we, prevent the risk of fire, not only with regard to the utilities, but also with regard to our environment, with climate change, with the built environment, making sure that we're building in a way that, minimizes fire risk. I will tell you, having worked on wildfire cases for over a decade, it's really hard to minimize fire risk once a wildfire starts going, but there are ways to do it. So there are a lot of discussions going on with the state, with experts on those kind of issues. And then, of course, the main discussion is how do we make sure that people who are impacted by these wildfires get their insurance money sooner rather than later. So, John and Stacy, you want to take one of these? Because I'm about to start coughing. I need some water. Sorry.
Honestly, I'm not that familiar with what's coming down in 2026. I do know that there have not been any major changes in the regulations in 2025. There were very few substantive changes. What I've been seeing is more a focus on the Department of Insurance looking to the insureds to better tighten up their fireproofing and offering often significant benefits to insureds if they are willing to do so. That seems to have been the focus of 2025. I would love to talk about 2026, but I actually don't know much about what's coming down the pike yet, so I would not be the right person to do that.
So I can, now that I'm no longer coughing, I can take it back. So there's on that note, the insurance commissioner, along with the Senate Insurance Committee chair, who is Stephen Padilla, who's out of San Diego, have proposed a bill. It is SB 876, and it's a fire and residential property insurance bill. It's billed as a comprehensive legislative reform to speed up disaster recovery for homeowners. So this proposed bill requires a disaster recovery plan from insurance companies handling claims, new timelines. In other words, how do you scale up quickly to manage these large disasters? They're not one-off insurance claims. So these insurance companies under this bill would have to have a disaster recovery plan. It would double penalties during a declared emergency for violations of insurance fair claims practices. It would require insurance companies to pay restitution directly to policyholders when they violate the law. It would address delays resulting from assigning, and this is a lot of, what we've dealt with in the last year, this assignment of multiple claims reps. You're getting passed from one to another, and that causes delay. It causes confusion. So this bill would address that. And require status reports to the policyholder within 5 days anytime a new adjuster is assigned. I think that would actually really be a great benefit because it's going to require this new adjuster to get up to date on your case sooner rather than later. It improves recovery by expanding policy limits another 100% if there's a declared disaster. And as Stacy mentioned, it has safer rebuilding requirements, mandatory building upgrades, coverage for the time of rebuild that are more focused on wildfire prevention. So that's SB 876. There's two more. SB
Hey, Amanda, real quick,
Go ahead.
the 100% extension on coverage, that's for ALE, correct?
Correct.
Not the total claim. It's just your alternative living expense when there's a declared emergency. They understand that it's going to take so long to get back rebuilt, et cetera. So that's where the 100% extension would be specifically, correct?
Exactly. Specifically, sorry if I didn't make that clear. And that really goes to a lot of the questions we had earlier about, when there are these mass disasters, as Stacy and John were mentioning, it takes longer to rebuild because there is
Yeah.
there's a strain on resources. And so this bill would address that extension that a number of people asked about earlier. SB 877, introduced by Senator Sasha Perez. She represents Altadena, Pasadena. And this also addresses insurance delays. It requires transparency and accountability in the loss estimate. Homeowners very often are just sent little bits of paper from their insurance companies, and it's really hard for them to piece together. So this would increase the requirements on, what kind of documentation would need to be maintained and provided to the insured. It would allow them to, it would address their issues of altering, reducing, rewriting loss estimates so that it's very, very confusing. And so bill will address those issues. And then a third one, SB 878, it's called the Insurance Payment Accountability Act. Strengthens existing prompt pay insurance laws by imposing interest penalties. So if your insurance companies are just taking too darn long to pay you, then there's going to be penalties on basically interest. They're going to be charged interest. California's deadlines requiring insurers to respond to claims promptly and pay out all undisputed amounts within 30 days are routinely evaded. And so that's going to be addressed with this insurance issue. It's going to address this, continuing problem of insurance companies, which I think is exacerbated most often by the switching in of these insurance claims reps, but it's going to address, the constant delay on payments and the need for people to follow up. So those are three bills: SB 876, 877, 878. Look into those. Definitely talk to your elected representatives if you want to make sure they support them, and encourage them to vote in favor of those. We got 5 more minutes. We can take some questions after that, but just one more thing, the California Wildfire Fund. So a lot of you have, heard about this. You probably weren't familiar with it before January 7th, 2025. And now it's, like insurance, one of those things you're intimately aware of. So for those of you who aren't, when PG&E up north filed for bankruptcy in 2019, and all of our clients from the 2015, 2017, and 2018 fires caused by PG&E in Northern California got pulled into the bankruptcy court. One of the things we did was lobby the state for essentially a safety net for the investor-owned utilities. We've got 3 of them in California: PG&E, SoCal Edison, and San Diego Gas and Electric. And the goal was to make sure that when they cause another one of these massive fires, there is an insurance safety net to make sure that they can compensate all the fire survivors and victims without having to go into bankruptcy and cause incredible delay in that compensation. So that original fund is AB 1054. 1054. That original fund is a fund of up to $21 billion. I think right now it's been funded to about 13. It funds generally at about $1.6 billion a year. And so that original fund happened. That fund is what Southern California Edison is going to be tapping into to make sure that it can cover all of the damages that it's going to need to pay out to Eaton fire survivors. We then, at the end of last year, the governor essentially wanted more of a backstop just in case, unfortunately, because we do have an epidemic of utility-caused wildfires in California. So SB 254 expanded and created an additional fund of $18 billion. That is only available for investor-owned utilities who cause fires after that bill is in place. So it's not going to help Eaton fire survivors or Palisade fire survivors, but it is for future fires. And then we've got on the a proposed legislation right now, AB 1554. So they're all ending in 54. Proposed legislation to implement more regulations to carry out wildfire mitigation and recovery. So under AB 1054, the investor-owned utilities have to create a wildfire safety plan every 3 years, and the California Earthquake Authority, which is actually the government entity that manages the California Wildfire Fund, they have to put out a report. The report's coming out in April 2026. It's going to have, a number of issues addressed, essentially relating to, a broader movement on control of the environment and landscape and utilities to mitigate wildfires. Because of course we can mitigate the cause, but we also need to mitigate the destructiveness and the spread. And that's hugely going to be addressed by managing the environment, managing the built environment and the landscape and the wildlands. So that report's coming out in April 2026. And AB 1554 is a proposed legislation. It's pretty vague, and it basically says, whatever's in that report that we think looks like it's beneficial and it's going to work, we want to put out some legislation to require enforcement of those proposals and those suggestions. So that's coming down too. So that's what's going on in 2026. Like I said, there's really a large movement right now towards how do we mitigate the cause of fire and the spread of fire across the state. It's our utilities. We do have an investor-owned utility problem in California, but they generally only cause about 10% of wildfires. They're generally their ignition they generally are only responsible for about 10% of the ignition of wildfires. Most wildfires are man-made. We did have a bunch of lightning strike wildfires, in like 2020, 2021 up in Northern California, but generally they are, human caused, either by accidents or arson or by our investor-owned utilities. But what makes them so destructive is, unfortunately, we've got huge amounts of overgrowth due to climate change. What happens in the winter is we have these excessive storms and they cause vegetation to grow very rapidly. And then we have spring comes and summer comes and everything dries out and we've got a lot of fuel. And obviously there's urban expansion into more rural areas. So it is a multifaceted issue. My practice area is holding utilities accountable, but there is a huge movement to mitigate the spread of these fires in the first place. And that's obviously a very important thing for our representatives to support. So that's what's on the horizon. Do we have time, Belinda, for questions? We just hit 11:01.
Absolutely.
Hey, Amanda,
You all
one
have
question
time to answer. Oh, sorry, John.
Go ahead.
I was going to say, somebody was asking if any of those bills are going to be retroactive to apply to the Palisades fire, and I don't believe they are. I don't know, but I saw that question. I don't know.
I doubt they are. Under the law,
I don't think you can
John
do
and
that.
Stacy knows, yeah, under the law, it's very, very rare that new legislation is retroactive. And if to make a legislation retroactive, it has to specifically state that it is. And I didn't see that that proposal
Yeah.
was in any of those bills.
If you all have time to answer questions, we will stay on until your hard stops kick in. So,
I have a very small amount of time. I accidentally left my calendar open after this and somebody booked an 11 a.m. call. I just told them I'm going to be a few minutes late. So if there are any questions I can specifically answer right now, I would be the best person to ask, please ask now and I will answer. And then I've got to go in about 5 minutes.
I've got to go in about 5 minutes as well. But yeah, Stacy, go ahead.
Well, I can pull some questions for you here. This is a good, I mean, this is one of those kind of basic insurance questions that we answer in the beginning. When the insurance company sends out correspondence after the house burns down, where does that correspondence go? That is a really important tip, which is if your house does burn down, one of the first things that you should do is open up a PO box. Because unfortunately, as a lot of people know, after these fires, you know end up in a rental, but then you move again. We've got clients in Eaton who have moved 10 times, 11 times for various reasons. So the best thing to do is open up a PO box so that you have a stable address, and then call all of your your credit card companies, your insurance company, all of those bills, and change your address to that PO box so that at least you have a stable address even if you have to move around.
And I see some questions in here about the extension of ALE for a federally declared disaster. As you noted, the 2026 bill is not likely to be retroactive, but there is already extension of ALE for up to 36 months if the amount in your policy covers it. So be aware of that. That may not help you in your individual situation, depending on how much coverage you had in the first place, but just be aware that you can extend it for up to 36 months. And I'm reading through the questions right now, so just making sure that I've answered anything that I personally know how to answer.
What impact will gridlock on declarations of disaster at FEMA have on wildfire claims? Have on wildfire claims. So the problem that we had in Eaton and Palisades, due to a changing of the administration and a difference in policy, I'll put it that way, was that so generally the way it works is the governor declares a state of emergency and then writes to the president and asks the president to declare to dispatch FEMA. That happened on January 7th when Joe Biden was still president. And then when Trump came into president on January 20th, the FEMA funds were minimized. And of course, there has been a movement to limit FEMA funds being dispatched. So right now, my understanding is FEMA still owes the state of California about $40 billion of money that the state of California had to put out fighting fires, or sorry, for debris removal and recovery, which would have otherwise come from FEMA. So that is going to have a huge impact. The other thing that we had in Eaton, I'm not sure if it happened to Palisades too, but I would expect that it did, is generally when FEMA comes in, they bring the Army Corps of Engineers. And the Army Corps of Engineers has a 3-phase cleanup. They first remove all hazardous materials so that residents can go back into their lot and look for anything that they can recover. Then they scrape the lot. And then the third phase is that FEMA and the Army Corps of Engineers will do soil contamination testing. That third phase was not done as a result or after the LA fires because FEMA did not allow the Army Corps of Engineers to pay for it. And as a result of that, as many people know, we've got a lot of independent soil contamination testing going on. So yeah, the politics is definitely going to impact that kind of issue.
And I'm afraid I need to go. But thank you very much for having me here. And I'm also, if anybody wants to contact me directly, I'm always happy to answer questions. I doesn't mean I'll be able to resolve your issue, but I can certainly answer questions. I'm always happy to do that.
Thank you so much for your time, Stacy. And I know, John, you said you had to go, and I think Amanda, we really appreciate it. The speaker's contact information is in your materials. And we have the questions. We have enough here, I think, for a whole other webinar. So if you registered for this and we're able to do a follow-up, we'll reach back out to you via email. Thank you so much, everybody.
All right.
Thank
Thank
you all.
you.
Thank you.